Do you have burning questions about a contract for deed or rent to own if you're considering one? Well, if you don't, you should. But here's your lucky strike. This is Mary Jo with H360 Homes, and I am here with Phaedra Howard of Helmuth & Johnson. She has 15 years working with Helmuth & Johnson solely on real estate. And we're going to talk about the difference between rent to own, contract for deed, what you need to know, rights and obligations. Phaedra, thank you so much for letting me invade your territory today. And people don't really understand the difference between a contract for deed and rent to own and what it really is. So, can you explain to us rent to own, what are their rights and what are their obligations?
Yep. So a rent to own is really you're a tenant. It's a landlord-tenant relationship with an option. And so you have the option to purchase at some point. That option needs to be put in writing, and it's signed at the time that the option is given. It's recorded in the property records. It sets forth the price and the other terms of which that renter can then purchase the property, the timeline of when they have to exercise that option, and that sort of thing. So unless they exercise it, they are a tenant. That's it. So they are not the owner of the property. They don't have any rights as an owner of the property. They only have tenants' rights, which obviously gives.
So their only their only real rights is a lease.
Correct. Yep. So they have that lease, and then they have that option. And options are typically for 1 to 5, 10 years that you have to exercise that option. It will say within that contract what you need to do, usually perform. So,
right.
When it's a purchase, you need to, come to the landlord and say, I'm ready to exercise it. Here's my money, set a closing date,
right,
that sorts of things. And then they honor that contract. So, that protects you if you think you want to buy in the future. You want to set a price now, which will protect you from inflation in the market. Because they can't raise the price if they've agreed to keep this.
If they have a contract.
If you have a contract in place, so they can't raise the price on you. And then you have that ability to say, I'm going to purchase it under those terms, or I'm not.
Have you ever run into the problem if nobody records it?
Well, of course that happens all the time, and then it's not valid.
Okay, so whose responsibility is it to have it recorded?
Really, either party can do that. If I'm the person that's getting the option, I would make sure that I would get it recorded because I'm the one who wants to have that ability in the future.
Yes, and if you don't record it, then you're dependent on your landlord whether he will honor it or not. I've seen that happen. Yep. A contract for deed. What are the buyer's rights and obligations, and how does that differ?
Yep. So a contract for deed is completely different from a rent to own. A contract for deed, the buyer is actually purchasing the property. They become the owner. But instead of getting a mortgage from a bank, the seller finances it. So they set the terms. Again, here's the purchase price. Here's what the monthly payments are, the interest rate, other terms like you have to insure it. If it's in an association, you're going to keep current with the association dues, all of that sort of thing. Who's paying the property taxes, which I always recommend the buyer should do that, but sometimes it's set up that the seller will pay the taxes. And then they are the owner of the property. The seller still holds the fee title, but it's as a security interest. So they become like a lender. So they are the secured party now. They are not the owner of the property. Once the buyer fulfills the contract, pays off all the payments, whether it's a 30-year or it's a 5. It's more typical to do like a 5-year with a balloon payment at the end.
Yes.
So the buyer will then get a mortgage. Maybe they can't qualify for one right now for whatever reason. So once that is fulfilled, then the seller executes that deed in fulfillment of the contract. But the seller is really treated as a secured party once that contract
as a
for deed
financing.
Yes, correct. It's a financing option for buyers that maybe you're self-employed and you don't have the income history or whatever the case might be where you can't qualify for that financing. So it's a very good tool. One thing that buyers need to know is that when you purchase on a contract for deed, if you default, it's much quicker process for the seller to cancel that contract.
It's like 90 days, correct?
60 days from the time that
60
they
days,
serve
okay.
you with the notice of default. You have to either cure it or the contract is canceled. If it's canceled, the buyer loses all equity in the property. So whatever you put down.
It's not like a foreclosure that can run on for a year.
Right. No, it's a much quicker process. And of course, that contract is going to be, the terms are going to be negotiated between the buyer and seller. And, of course, if we're representing the buyer, we're going to negotiate different terms than if we're representing the seller.
Well, obviously, this is different than a bank because it depends on the buyer and seller. The buyer will write the contract, or the agent of the buyer will write the contract and the terms in there, and the seller, they can negotiate back and forth instead of with the lender. Correct?
Yeah, I mean, frankly, as an attorney, I don't recommend that the agent write the contract. I would recommend that they go to an attorney, unless the agent is really, experienced in handling these things, because there are different terms and things that can be, added in an addendum and that sort of thing to better protect the rights of the buyer or seller, depending on what side you're on, than the standard form.
Okay. Oh, yeah, we do use the standard forms. So who can close on a contract for deed? Okay, I usually go to a title company, but can an attorney close it?
Yeah, I mean, there's no, because it's not a typical situation where you've got, a bank and you may not even have title insurance, although you should, as a buyer, still get a owner's policy, but there's not going to be a lender's policy. So there's a lot more freedom. I mean, some people do it on their own without any kind of closing agent. Again, it depends on who the parties are. If they're related to each other, sure, fine.
Maybe.
Maybe. Maybe not.
Maybe. Yeah, there's always one shark in the family. But it is the buyer's responsibility to have it recorded.
Correct, and it needs to be recorded within 4 months of execution.
Otherwise, there is a fine from the state of Minnesota.
There can be. The counties aren't really following up on that, because how do they know that there's an unrecorded contract?
Well, that's true.
But yes, I mean, there are civil penalties that exist. Whether that gets followed up on, the bigger issue is not getting that of record. So if there are other, liens or things out there, or, other potential clouds on title, you want to get that contract in place to protect your rights.
If there are other liens, can that contract be in the first place?
It depends. So if when you're that's the weird thing about a contract for deed, is that there's the buyer's interest and the seller's interest, and liens can affect one or the other, sometimes both.
Okay.
But for example, if the seller has a mortgage and the buyer says, yes, I know there's a mortgage on there, I'm willing to take subject to that, that's going to affect their interest. But after the contract is signed and recorded, if the seller goes and gets a new mortgage, or if the buyer gets some sort of lien or mortgage or something, they're only going to affect that person's interest and not the other person's.
Oh, good to know. I hope this has been informative. And if you have further questions, you can call me or you can call Phaedra, and we'll have her contact information right below. Phaedra, thank you. That was so informative. And stay tuned. We'll have more about Ask an Attorney. Thanks for watching. It's Mary Jo, and click to subscribe right below.